on the record in the matter of the people of the state of Michigan versus Gage Riley McConnell. The file number is 21-00740FY. Council appearance.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. McConnell, who's present and standing to my right.
Today's date set for a preliminary examination. Are we ready to proceed?
The people are, Your Honor.
Defensive.
Okay, any preliminary matters?
Yes, Your Honor. Thank you. At this time, the people are moving to amend the complaint to include an added count 2 in the alternative of assault with intent to do great bodily harm less than murder, assault by strangulation or suffocation, pursuant to 750.84.
Okay, and is that based on the original affidavit and police report? Or are you going to present facts to support that?
I believe it's in the police report, Your Honor, but certainly the witness will testify to that
Okay.
today as well.
Any additional matters for the people?
No, thank you.
Yes?
Just on the request to amend, I would ask that the court hold off any decision on that until after proofs have been taken. As the original probable cause determination and determination by the prosecutor's office was to charge this an aggravated domestic violence second and not a GBH.
The court will hold off on the determination until the proofs presented. Any additional matters before we proceed?
No
Nothing-
additional matters for the defense.
Nothing for the people, Your Honor. Thank you.
And you can call your first witness.
Thank you, Your Honor. The people would call to the stand Officer Owen Rogus.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. Take a seat here, sir. State your first and last name and spell your last name for the record.
Officer Owen Rogus, last name is Rogus.
You can proceed, counsel.
Thank you, Your Honor. Good morning, sir. Could you please state your occupation?
Law enforcement with Lansing Police Department.
And how long have you been with the Lansing Police Department?
A little over a year now.
Were you on duty on February 15th, 2021?
Yes, I was.
And what did your duties that day include?
Taking calls, doing traffic stops, everything on a normal day.
And on that date, were you dispatched to 404 West Berry Avenue?
Yes, I was.
Are you familiar with the Lansing city limits?
Yes, I am.
And is that location within the city of Lansing, county of Ingham, state of Michigan?
Yes, it is.
And why were you dispatched?
There was reports of a late domestic assault.
And when you say late domestic assault, what do you mean by that, sir?
And it means that at the time I arrived, the assault didn't just happen, or I didn't arrive on scene. It was a few hours after the call or the assault.
And when you arrived, did you make contact with anyone?
Yes, I did.
And who did you make contact with?
Caitlin Thuma.
And who did you determine Caitlin Thuma to be?
She was the victim of the assault.
Did she describe the assault to you?
Yes, she did.
And did she describe or provide you with information as to a suspect?
Yes, she did.
And who did she?
Objection, Your Honor, hearsay.
Thank you, Your Honor. The people intend to proceed under MCL 768.27C. In order to do that, Your Honor, the people have to provide a foundation that the testimony as provided by law enforcement will detail an assault in a domestic capacity. In order to do that, Your Honor, the people must initially have the officer testify to those foundational issues and then receive permission from the court to proceed.
Okay, so the testimony elicited is not for the truth of the matter asserted, but to lay the foundation for 27C.
For the time being, Your Honor, and then will become for the truth of the matter asserted if the court allows the people to proceed under the statute, yes.
The objections overruled.
Thank you. Sir, did she provide you with a name?
Yes, she did.
And what was that name?
Gage McConnell,
Did she provide you with any other information?
date of birth.
And did she describe to you the relationship between herself and Gage McConnell?
Yes, she did.
And what did she advise that to be?
She said they've been dating for 1.5 years and living together for approximately 10 months.
Thank you. Your Honor, the people believe at this time that they have laid a proper foundation to proceed with the officer's testimony of the victim's out-of-court statements pursuant to 768.27C, and would ask permission to proceed.
Your objection is already noted.
Thank you.
Okay, and if it's overruled, you can proceed.
Thank you, Your Honor. Sir, what did Ms. Thuma advise you regarding the assault?
Ms. Thuma said that at approximately 9 to 9:30 at night, she and Mr. McConnell got into an argument that continued up until midnight. At approximately midnight on the 15th, there was an assault that took place. Ms. Thuma said that Mr. McConnell tackled her, pinned her to the ground with his knees, and punched her in the face multiple times. Ms. Thuma also said that she attempted to fight back and try to get Mr. McConnell off of her and kicked him in the face. At that point, he continued with the assault, and Ms. Thuma said the assault ended once she told him that she was bleeding from the ears.
Did she provide you any other statements about what happened following the assault?
Yes, she did.
And what was that?
That after the assault happened, Mr. McConnell,
Objection, Your Honor. I would object to this specific statement as it's not relevant to, it's not testimony relating to an assault or any instance of domestic violence, and therefore it's not within the scope of 27C.
Counsel, did you want to respond?
Thank you, Your Honor. Well, before hearing what the officer has to say, I don't know that Mr. Nickel can provide that objection. If the court were to allow the officer to testify, he's going to testify to an action that was done by the defendant, which the people would argue is a continuing portion of the domestic assault. The statute defines what is included. It is more broad than just simply the physical assault. And if the defendant is doing something to attempt to cover up that assault, which would be the proffer that the people would make of what the evidence will show, then that would be relevant for this court's consideration as it goes to what occurred.
Okay, your objection is noted. I'll allow him an opportunity to give a response, and then I'll make a ruling on the objection.
Thank you.
Thank you. Sir, do you recall the question? Thank you. What I asked you is, did Ms. McConnell provide you any statement about what happened after the physical assault?
yes, she did.
And what was that?
She said that Mr. McConnell took her to the shower and was washing her off while he was crying over the assault.
Thank you. Now, did you note any injuries to?
Let me address
Oh,
the objection.
So-
No problem.
I would continue to object and move to strike that statement. 27C specifically states that evidence of a statement of declarant is admissible if all of the following apply. And A is the statement purports to narrate, describe, or explain the infliction or threat of physical injury upon the declarant. Showering her off, bathing her, that's not the infliction or threat of physical injury upon the declarant.
What about B or C? I mean, the action is in which the evidence is offered under this section is an offense involving domestic violence, which the testimony just elicited would be relevant to an offense involving domestic violence. And then C, the statement that was made at or near the time of the infliction or threat of physical injury. So this was in response to what he did immediately following an assault.
So it's all of the following have to apply. If A does not apply, it doesn't matter whether B, C, D, or E apply. If A does not apply, it's not within the scope of 27C. Therefore, it's not admissible at any hearing. And I would ask that the court strike that testimony.
Did you want to respond, Counsel?
Yes, Your Honor, thank you. I don't disagree with Mr. Nichols' last statement. However, sub A, Your Honor, is a very broad narrate, describe, or explain. And so the officer's testimony, based on the victim's statement, was that the defendant carried her to the shower and showered her off while crying over the assault. That certainly is an explanation of part of the infliction of the assault, because it shows an admission by actions, Your Honor, and an attempt to cover up the injuries resulting from this particular physical assault. I believe that it would be covered under this, and the court can consider that statement.
I would agree that the testimony elicited would be applicable to all subsections A, B, and C. So the objections overruled.
Thank you, Your Honor.
Thank you, Honor.
And my apologies for moving on so quickly, Your Honor. Sir, did you note any injuries while speaking with the victim?
Yes, I did.
Could you describe those for the court, please?
She had swelling on her face. I noted that she had a black eye and at least one eye that was noticeable, and that there was dry blood in her ears at the time of contact.
And did you take any photographs of the victim?
Yes, I did.
And were those taken on the date of February 15th, 2021, when you initially made contact?
Yes, they were.
Were those taken by you?
Yes.
Your Honor, may I approach the witness?
You may.
Thank you. Sir, I have just handed you 6 separate papers. They are marked as People's Proposed Exhibits 1 through 6 by a yellow sticker. Do you see that?
Yes, I do.
And as you look through those, I'm going to ask you a group question of looking through all 6. Are those photographs, are they photographs?
Yes.
Okay, and are those photographs taken by you?
Yes.
Were those the photographs taken by you on February 15th, 2021 of the victim as you are here testifying? And do each 1 through 6 of those photographs accurately depict the injuries as you observed them?
Yes.
Thank you, Your Honor. At this time, I would move for admission of People's Proposed Exhibits 1 through 6.
Any objection?
No objection for the purposes of the exam, Your Honor. Thank you.
1 through 6 are admitted.
Thank you. And may I approach one more time, Your Honor?
Yeah.
Thank you. Sir, I'm going to direct your attention to People's Exhibit 5. I've placed it on the top of the stack there. Could you take a look at that, please?
Yep.
And what is depicted in that photograph?
That would be her right hand with an abrasion on the pinky finger.
And what, if anything, based on your training and experience, do you note about that particular injury?
That injury is usually in reference to trying to fight off an assailant or someone that's assaulting someone.
Now, after speaking with Ms. Thuma and receiving the information of Gage McConnell and a date of birth, what did you do?
We attempted to conduct follow-up. The victim told us that he might be at his mother's house, so we attempted to make contact at his mother's house.
And did you look up the suspect by the information provided in any database?
Yes.
And what database did you utilize?
We used Lean to look up his Secretary of State picture.
Objection, Your Honor. Hearsay.
Objection overruled.
And what information does Lean provide to a law enforcement officer?
Provides an address, full of name, date of birth, and a photo ID.
And did you, looking at Lean, observe his photograph?
Yes, I did.
And do you see in the courtroom today the person?
Objection, Your Honor. Hearsay. He's testifying to what he saw in a piece of evidence that is not at issue in this court.
Are you referencing the lien?
Yes.
What was it to say? Because she hasn't completed the question yet. Oh, for the
He-
next question. So,
I'm objecting to him testifying about what he looked up in Lean.
okay, did you want to respond to the objection as to the lien reference?
Thank you, Your Honor. A photograph is not hearsay under the rule regarding what is hearsay. So for him to testify about looking at a photograph and what his testimony would be in a courtroom ID based on a photograph he saw is not hearsay under the court rule.
Objections overruled.
Do you recall the question? I don't know that I do. So I'm going to phrase it again.
For an ID.
Yes, I'm not attempting to get a different question in is what I'm advising the court. Sir, I asked you if you looked at the lien information and looked at a photograph of the person identified as Gage McConnell. Did you do that?
Yes, I I do.
Okay, and do you see anyone in the courtroom today that would match that photograph?
Yes, I do.
Okay, and could you please indicate for the court what the subject in court today is wearing?
He's wearing a blue button-down shirt.
Thank you, Your Honor. I would ask that the record reflect that the witness has identified the defendant.
Any objection to identification?
Yes, I would object to identification at this time. He identified that Mr. McConnell, or that my client, matches a picture he witnessed on Lane. There's no sufficient foundation as to whether that picture is the individual that Ms. Thuma was alleging was with her at 404 West Berry Street at this time.
Okay,
We don't know if Ms. Berry actually identified that picture as who she was speaking to when she said that Gage McConnell or her boyfriend assaulted her.
And Ms. Hospital?
Thank you, Your Honor. What we have linking the evidence together is that Ms. Thuma made a statement to the officer of a name and date of birth. The officer then put that information, name and date of birth, into a database that is run by the state of Michigan and provides a variety of information as the officer testified. He looked at a photograph associated with that name and date of birth received from the victim and determined that the person identified in that photograph as provided by Ms. Thuma is sitting in the courtroom today. I believe that that is an appropriate link, and it certainly establishes the probable cause level needed for this particular hearing.
Okay. For a probable cause standard, I would agree, but I don't know if you want to elicit any additional testimony as to whether or not the victim provided description or anything at all, and that might help address this objection.
I certainly can, Your Honor, and I will let the officer testify. In addition to a name and date of birth, did the victim provide you with any additional descriptive information of the suspect?
Simply that he was a white male.
Thank you.
The objection's overruled.
Now, you indicated that you attempted to make contact at his mother's address. Is that correct, sir?
Yes, sir.
And how did you determine the address of the mother?
Through talking with Ms. Thuma and also through me.
And did you proceed to that location?
Yes.
Did you make contact with the defendant at that location?
No, I did not.
What did you do after that?
After that, I followed up with the victim and called her and made sure she was okay and what she was doing, and she informed me that she was going to the hospital.
Thank you. Your Honor, I have no further questions for this witness at this time.
Cross-examination.
Yes.
So Officer Rogas, it'd be fair to say you weren't present on February 15th when any alleged assault was occurring?
Correct.
So you don't know what actually occurred between Ms. Thuma and any individual she claims assaulted her?
Correct.
You don't know whether her statements, any of her statements are true or not? She stated that Mr. McConnell, or the individual she's talking about, tackled her
Correct.
and then punched her.
Correct.
Did she say how many times?
She did not.
And she stated that at some point she kicked this individual in the face.
Correct.
And that caused the individual to have a bloody nose.
Correct.
And you didn't make contact with Mr. McConnell at any point during your investigation?
No, sir.
So you don't know whether or not he had a bloody nose?
Correct.
And she testified that when she informed Mr. McConnell that she was bleeding from the ears, he stopped. But she wasn't bleeding from the ears when you saw her.
No.
And again, you don't know whether she actually made that statement to Mr. McConnell,
I'm sorry, sir, what statement?
that she was bleeding from the ears?
No, I did not.
And you don't know that if she did make that statement, you don't know if she was actually bleeding. But it was her statement to you that once she said that, Mr. McConnell stopped assaulting her. And when it was on, when you were on scene, she declined an ambulance?
Correct.
Stated, but may have gone to the hospital later?
Correct.
Are you in possession of any medical records establishing that she went to the hospital?
I am not.
Did she ever send those? So she never sent those to you? So you have no idea the extent of the injuries she sustained that day? Other than obviously what can be seen in the pictures, which is some abrasions and some cuts. Fair to say that when you were speaking with Ms. McConnell, she had difficulty remembering some of the events that occurred that day?
Correct.
I'm sorry, just to correct the record, he wouldn't have been speaking with Ms. McConnell, he would have been speaking with Ms. Suma.
I'll rephrase the question. When you're speaking with Ms. Suma, she was having difficulty remembering some of the events that day?
Correct.
I have no further questions.
Very briefly, Aaron, thank you. Sir, just to clarify, Mr. Nickel asked you a few questions about Ms. Suma's ears. Is it fair to say that she wasn't actively bleeding?
Correct.
Okay. Now, what, if any, observations did you make about her ears?
There was dry blood in the ears at the time of contact.
Thank you. Now, have you had occasion, other than this particular incident, to investigate matters of domestic violence? And in your experience, is it common for someone who has just undergone that type of traumatic event to have difficulty remembering things?
Yes.
And I believe the defense attorney asked you if she may have received medical treatment, but did she in fact make a statement to you about more affirmatively than may?
She said that she was going to Sparrow at the time when I called her.
Thank you. I have nothing further at this time for this witness, Your Honor. Yes, Your Honor. Thank you.
Can you call your next witness?
Thank you, Your Honor. The people have no further witnesses.
Did you want to,
I will bring them to you, Your Honor. May I approach?
does the defense call any witnesses today?
No witnesses from the defense, Your Honor.
Thank you. Thank you, Your Honor. In this matter, I would renew at this time the people's motion to add in the alternative a count 2 of great bodily harm assault with the great bodily harm pursuant to 750.84.
And you are renewing that based on what evidence presented today?
Thank you, Your Honor. If the court looks at the jury instruction, which is jury instruction 17.7, the elements of that particular offense are that the defendant tried to physically injure another person, that at the time of the assault, the defendant had the ability to cause an injury or at least believed that he had the ability, and that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there is an injury, the jury, or in this case, the finder of fact, may consider it. A great bodily harm, Your Honor, means any physical injury that would seriously harm the health or function of the body. And certainly the testimony here, Your Honor, from the officer on behalf of the victim and the pictures, Your Honor, would support the position that there was great bodily harm. The injuries to the defendant, or pardon me, please, to the victim's face are extensive. The black eyes, the cuts above the eyebrow, the fact that she advised the officer that the assault caused her to bleed from the ears, which was supported by the officer's observations of dried blood in the ears, maybe less than what would have been there, but also consistent with the testimony that the defendant attempted to shower her off to remove the blood after the assault. So the people would put forth to the court that there is evidence to support and in the alternative count of the great bodily harm.
Actually want to add it as an alternative.
Thank you, Your Honor. And with regard to a bind over motion, Your Honor, then before this court is the consideration of the two felonies, the aggravated domestic violence and the assault with great bodily harm. The people would, with regard to count one, establish by the testimony that there was an assault, there was a domestic relationship as established by the officer's testimony that they had been in a dating relationship for 1.5 years and had resided together for approximately 10 months. The officer testified based on the victim's statements of the assault that occurred. And again, going with the injuries as I have just described them with regard to count two, certainly that would establish, Your Honor, a serious or aggravated injury, which is a physical injury that requires an immediate medical treatment or that causes a disfigurement, impairment of the health or impairment of a part of the body. The court has before it the pictures and heard the testimony. When an assault occurs, Your Honor, where the extent of the physical assault is such that it causes the body to bleed from the ears, certainly the people have, by a finding of probable cause, established both the serious or aggravated injury and the great bodily harm. People would ask that this matter be bound over as to both count one and in the alternative count two.
Mr. Nichol?
Yes. Starting with obviously the more serious charge with the request to add an assault with intent to do great bodily harm, but as the court not bind over on that count as the evidence presented to the court today is not sufficient to meet the burden even of a probable cause standard that an assault with intent to do great bodily harm less than the crime of murder occurred here. Specifically focusing on the third element that the defendant intended to cause great bodily harm. This is a specific intent crime. And so it's not just the injuries that the court has to consider, but the court needs to consider whether the injuries and all of the other evidence suggest that it was the intent of the defendant to cause great bodily harm. In this case, Officer Rogas testified that the only information he got as to the nature of the assault was that Ms. Thuma was tackled and that she was punched. But there's no specific statements as to how many times she was punched. There's no specific evidence that she actually was bleeding from the ears at any point during this assault. Just that she made that statement and as she stated, Mr. McConnell stopped the assault. Even if that were to be taken true that she did make that statement and that Mr. McConnell did stop, that would evidence that Mr. McConnell's intent, if he was the individual there that day interacting with Ms. Thuma, causing these injuries, did not intend to cause great bodily harm. When it was made clear to him that there might be that level of injury, the assault was stopped and assistance was given. Further, so I would argue that there is insufficient evidence to show that there is even probable cause to believe that this incident occurred with the specific intent to cause great bodily harm. Further, as far as the injuries are concerned, well, there are injuries, there are photographs of them. There's no medical evidence. There's no information presented as to what the actual severity of any injuries she suffered was, other than what can be seen, and whether there was any chance that any of these injuries could seriously harm the health or function of the body. With respect to both count one and count two, I would again maintain an objection that there's insufficient evidence to identify the defendant sitting before the court today as the individual that Ms. Thuma identified or stated assaulted her. Mr. Officer Rogas never made any contact with Mr. McConnell. He did not get any more than a description that Mr. McConnell was a white man. That's about as vague of a description as I could possibly think of. He did not show Ms. McConnell the picture he pulled up to ask her whether that individual was the Gage McConnell that she was speaking of. And so, Your Honor, respectfully, even at a probable cause standard, I would argue that identification has not been met, and it is an absolute requirement of each and every criminal offense So I would ask the court not to bind over on either charge, but specifically not to bind over on the newly added or requested charge of assault with intent to do great bodily harm less than murder. Thank you.
Yes, Your Honor, just very briefly to the idea of intent. I think there was intent here, and it can be taken from the defendant's actions. When the officer testified, and essentially what the court is using with that officer's testimony is the victim's testimony. And so what we know from her statement is that she was pinned to the ground. So she was tackled and pinned to the ground. That goes to intent, Your Honor. She is being assaulted in a position where she's pinned and unable to move. This is not someone who could run or flee away. We next look at the assault itself, and it didn't stop, according to the officer's statements of the victim, even when she punched him and he himself had a bloody nose. That also goes to intent. When the defense attorney tries to say that his client, at the time that he became aware of the extent of the injuries, stopped, first then we already have an extent of injuries, because if we're getting to use that to show why it is that he stopped, we already have those injuries stated. And also, assistance wasn't given, Your Honor. Putting someone in a shower to wash away the blood is not an assistance. Leaving the home when she's still there is not an assistance. An assistance, if he thinks that the injuries are so extensive, is to call for medical help, is to take her in for medical help. So essentially, what that shows, Your Honor, is that the assault had occurred, and it was so great that he attempted to cover it up and then fled the scene. Certainly, the people have established enough at a probable cause level, Your Honor, to proceed with that alternative count. And as to ID, Your Honor, certainly if an officer in the course of a regular traffic stop can use a state-produced identification card or a state-produced driver's license to determine who it is that is in front of them, and that's all the further verification that's used, then an officer can use that same identification card based on information from the victim and make an in-court ID today. So the people would again ask that this matter be bound over with count 1 and in the alternative count 2.
It's a date that was set for preliminary examination, and the burden is that just a probable cause, what's probable cause that a crime was committed, probable cause to charge you, Mr. McConnell, with the crime. We heard the testimony evidence today of Officer Owen Rogus. He said he appeared to the address of 404 Westbury Avenue in Lansing on the date of February 15, 2021, making venue appropriate. And he was appearing in report of a late domestic. He spoke with an alleged victim being a Caitlin Thuma. Miss Thuma described an assault that she stated that her boyfriend, who she said they had been living together, they had been arguing during the day, and then it resulted or escalated into what she described as an attack, that he tackled her, pinned her to the ground, and punched her. Based on the officer's statement of the victim's report, it was that the assault ended when the victim stated that there was blood, or she was bleeding from the ear. There was also testimony provided that the defendant then tried to wash the victim off or wash the blood off. The officer testified that the victim at the time of the report had swelling in her face and eyes, and then her ear, there was dried blood in there. The court has People's Exhibits 1 through 6, which are demonstrative of some injuries. There are very swollen black eyes on both pictures, on both eyes. There also appears to be some blood above the eyes in the pictures from Exhibits 1 and 2. There's also pictures of the ear. So this is the right ear and the left ear. And there appears to be some dried blood on the inside of the victim's ear. The officer testified that the victim later reported to him that she needed to go to Sparrow for medical treatment. The officer testified that the victim provided him with a name and date of birth of her boyfriend, the alleged accused here in this matter, and stated that he was a white male, and the officer used lean in order to identify or pull up the Secretary of State information of the defendant. He never made contact with the defendant at that date. I think he sought him out at the mother's house. As to whether or not identification is sufficient, the court believes that identification is sufficient at this time, and the court also is satisfied with that there is sufficient probable cause to both grant the request to add a count 2 in the alternative of assault with intent to do great bodily harm less than murder or by strangulation, and that's based on the testimony of the officer as to the nature of the assault as described by the victim, and then also the review of the pictures here, which would demonstrate severe injuries to the eye and possibly to the ear if the ear was bleeding, based on the testimony of the officer and the picture, and then also that the victim then needed some medical attention. I understand that the argument of defense is that there is no medical records. This is not a trial, and there's no burden for beyond a reasonable doubt. It's just probable cause, and so there's sufficient evidence to find over as to count 1, domestic violence aggravated, and count 2 as added by the request of the prosecution's motion. These matters will be bound over to the circuit court for a date for October 13th. Mr. McConnell, you do not need to appear in court on that date. It's just the date that they'll get the file from this court. When the circuit court receives the file, they'll set your next court date. It will be a pretrial in circuit court. Your attorney will be made aware of that date. You stay in communication with them, okay?
Yes, Your Honor.
Are you still at the address that you provided at your arraignment, which is on Openness Road?
Yes, Your Honor.
Phone number still ends in 4129.
Yes, Your Honor. Could I also add an additional phone number in case?
Okay.
720, that's the area code, 569-0364. That's my mother's number, and as of right now, I stay at her residence.
Okay, I will note that here in the file. Do you have any questions for the court today?
No, Your Honor.
Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
Nothing for the defense, Your Honor.
You're all set. We're off the record.
Your Honor, I believe that's all the files.
I believe that's all I have as well.
Great, thank you.
Thank you.
May I have my exhibit back, Mr. Bigelow?
I am thinking.
Oh, I'm sorry, Your Honor. Thank you. Didn't realize. All right.